Imagine this. You work in a factory. One morning, you reach the factory, but the workers refuse to enter. The next day, the workers are ready to work, but the employer says, no work today. The factory is closed. A few days later, the factory opens, but some workers are told, we don't have work for you right now. And then one worker receives a letter saying, your services are terminated. Now tell me, are all four situations the same? Absolutely not. They are called strike, lockout, layoff, and retrenchment. And if you are a law student, confusing these four terms can cost you marks in your labor law examination. So, in the next few minutes, let us make these four concepts impossible to forget. Let's start with strike. Imagine 500 workers in a factory are unhappy with their wages. They discuss the matter and collectively decide until the dispute is resolved, we will not work. They stop working. That is a strike. Under Section 2Q of the Industrial Dispute Act 1947, a strike involves workers collectively stopping work or refusing to continue working. So remember just one thing. Strike is equal to workers stop working. The action comes from the workers. Now let's reverse the situation. The workers are ready to work. They come to the factory, but the employer says, the factory is closed, you cannot work. That is a lockout. Under Section 2I of the Industrial Dispute Act 1947, lockout refers to the temporary closing of a place of employment or suspension, refusal by the employer to continue to employ workers. So here is your memory trick. Strike, workers stop work, lockout, employer stops work. Simple, right? But now comes the confusing part. Suppose the employer actually wants the workers to work, but suddenly there is no electricity, or the machinery breaks down, or raw materials don't arrive, or there is an accumulation of stock. The factory cannot provide work to some workers. But here is the important part. The employer has not terminated them. They are still employees. They are simply not being provided work temporarily. This is called layoff. It is covered under Section 2 KKK of the Industrial Dispute Act 1947. So remember, layoff is equal to temporary no work. The employment relationship continues. Now imagine something completely different. The company decides we have more workers than we need. Now imagine something completely different. The company decides we have no we have more workers than we need. The employer permanently terminates the services of some workers, subject to the statutory requirements and exceptions. This is a retrenchment. It is defined under Section 200 of the Industrial Dispute Act 1947. And this is the key difference. Layoff is equal to temporary. Retrenchment is equal to termination of service. This is where many students make mistakes in the examination. Let's forget the legal language for a moment. Just remember four words: strike, workers; lockout, employer; layoff, temporary; retrenchment, termination. So it once with me: worker, employer, temporary, termination. That's your entire basic concept. But there is one more thing. What if the employer asks, what if the examiner asks, distinguish between layoff and retrenchment? Don't panic. Think about this situation. In layoff, the employer is basically saying, I don't have work for you right now. In retrenchment, the employer is saying, your employment is being terminated. That's the fundamental difference. One case law you should remember. Now, if you want to make any answer stronger in the exam, remember this case. State Bank of India versus N. Sundara Mani, 1976. The Supreme Court gave an important interpretation of retrenchment under Section 200 of the Industrial Dispute Act. So whenever you write an answer on retrenchment, this case can be very useful. Okay, let's see if you understood it. Workers refuse to work collectively. What is it? Strike. Employer temporarily closes the workplace. Lockout. Employer cannot provide work because of shortage of raw material or similar reasons. Layoff. Workers' service is terminated subject to statutory exceptions, that is retrenchment. If you got all four right, you have got the basic concepts. And that's the simple difference between strike, like layout, lockout, layoff, and retrenchment. Remember, strike, worker stops; lockout, employer stops; layoff, work stops but temporarily; retrenchment, service ends. If this explanation made labor law easier for you, subscribe to Yo Vakil. Because here we don't just memorize legal definitions, we understand the law. See you in the next one.